Welcome once again to Lehto's Law. Here's Steve Lehto.
Pretty much everyone in my audience sent me the following story. Thank you very much. Crowdsourcing the good stories. And I've talked before about how police want to search your car. Police want to search your car. It's just something they do, and it's part of their job that after a while of being a police officer, you just want to pull people over and search their cars. So what happens is a lot of times they'll pull somebody over and they'll talk to them for a little bit and they'll realize they've got no good cause to insist on a search. So they'll ask, may we search your car? And if you watch enough of those cop shows on TV, you've seen it before, and they ask, may we search your car? And some people say, sure, go ahead. And then it turns out they got all kinds of contraband in there and stuff. But also, sometimes people go, I'd rather not. And as people have commented under one of my videos about when can police search your car, they then say, oh, I smell marijuana. I smell marijuana. And the thing about that is how would they prove that they did or did not? How would you prove that they did not? And I've heard from people before who said that they were told that despite the fact they've never touched the stuff. And it's just one of those things. And I've seen a police officer in court, I've told the story before, tell a judge, as I approached the car, there's a strong odor of marijuana emanating from it, despite the fact that all the windows were rolled up and it was the wintertime. So the judge laughed at the police officer and threw everything out from the ensuing search. So the question is, that story I just told you happened back when it was illegal to smoke it under any circumstances in the state of Michigan. But now there are circumstances where it is in fact legal. So that's changing state by state. And so the question becomes, if you're in a state where it's sometimes legal or all the time legal to possess it or use it or whatever, can a police officer use that as the basis to search your car? And it's being litigated state by state. And what happens is there's a ruling on it that makes the news. That gets appealed a little while later. There's a ruling on it there. That gets appealed. And these are working their way up the system. And so right now, these are now starting to hit state Supreme Courts. So according to the Associated Press, which is the story I'm reading right now, pot smell alone can't form basis for a vehicle search, according to a Pennsylvania court. Pennsylvania appeals court reversed a judge's ruling that state police didn't have a valid legal reason for searching a car just because it smelled like cannabis, saying she failed to weigh other factors that led to the man's arrest. But the state Superior Court agreed with Lehigh County Judge Maria Dantos that the smell of marijuana alone is not enough to give police the right to search a car without a warrant. But the appeals court reversed the decision to suppress the evidence in the arrest, saying that the judge didn't take other evidence into account and so should probably take another look at that. The appeals court sent the case back to Lehigh County for review. Another judge will handle the case since Dantos has since retired. That's a bummer. You work on a case, it goes up, gets sent back to you for review, and you no longer work there. The police search yielded a weapon and a small amount of marijuana in an unmarked plastic baggie. The passenger in the car was charged with illegally possessing the weapon and possessing a small amount of marijuana. But the judge suppressed the evidence, noting that the man had a medical marijuana card. A medical marijuana card. So he's got a medical marijuana card and he's a passenger. Then what's the problem? In her opinion last year, the judge wrote that the plain smell of marijuana alone no longer provides authorities with probable cause to conduct a search of a subject vehicle because it's no longer indicative of an illegal or criminal act. She said that once the man presented his medical marijuana card, it was illogical, impractical, and unreasonable for troopers to conclude that the crime had been committed. Sounds like a string of words Jackie Childs had put together. Illogical, impractical, and unreasonable. Prosecutors appealed and Superior Court said that the judge's decision to suppress the evidence in the case was not legally sufficient, and the man's attorney called the ruling a victory, but one which could have been clearer and more robust. He said the appeals court expressly rejected most of the prosecution's arguments. So what they're getting at here is if the police had simply said, the only reason we searched the car was because we smelled marijuana. It's the only reason. If they had testified to any other possible reasons, then maybe they had a reason to do it. So that's what it's going to boil down to. They probably have another hearing and let the police officers now adjust their testimony. Prosecutors argue the search was legal under state Supreme Court precedent. For nearly 100 years, the U.S. Supreme Court has recognized an automobile exception to the Fourth Amendment's ban on unreasonable searches and seizures, giving law enforcement the right to conduct a warrantless search if there is reason to suspect a vehicle is hiding contraband or evidence of a crime. Police have long used the exception to conduct vehicle searches based on the pungent, distinctive odor of pot. Of course, the question is, the odor of pot in a time when it is legal and a man has a medical marijuana card is not necessarily evidence of a crime. Increasingly, motorists in states where marijuana is legal in some form are pushing back when police insist on a search, especially if that search yields evidence of a crime, and especially if it's something other than the marijuana, which they claim was their initial reason for searching the vehicle. So this is the case I'm pretty sure I did a video about not too long back, but I did the video after the trial court had ruled. And I've mentioned before, and this is the kind of thing, I have to mention this from time to time simply because some people don't follow the procedure. And I understand, lawyers understand this stuff, but very few other people do unless they really study the law. But there are trial courts. Okay, you get arrested and you're put on trial. You're tried in a trial court. So the trial court is where either a judge hears the evidence, makes a ruling if it's a bench trial, or a jury hears the evidence and they issue a verdict. Judge enters the verdict and so on, and that's a trial court. So there are trial courts that have criminal cases. There are trial courts that have civil cases. They might have different levels of trial courts. Like in Michigan, we've got state district courts that handle misdemeanors and landlord-tenant matters. And then we've got circuit courts that handle felonies and divorces, things of that nature. But those are the trial courts. If a ruling comes out of a trial court that one party doesn't like, they can appeal that ruling, generally speaking. So they appeal the ruling up to a court of appeals. Now, some states call those different things, but they're often just simply appellate courts because they're courts where you appeal something. And then if you get a ruling from an appeals court that you don't like, you can usually ask your state's Supreme Court if, in fact, there's a court above that level. And sometimes you have to appeal straight to the Supreme Court. There's a couple states out west, I believe, that only have straight from trial courts to the Supreme Court. That you then ask that highest court to review what the appellate court did and issue a ruling. And if you look at the structure of the courts coming down from the highest court in the land, and I'm talking about states here. So you have a state Supreme Court, and you have this intermediate appellate series of courts, and then below that you've got the trial courts. View it like it's a pyramid almost, okay? Because there are more down here, and it narrows up to the top. And the same is true in the federal system, okay? You've got district courts, federal district courts. Then you've got federal district courts of appeal, and then you have the U.S. Supreme Court. And that one is easier to follow because the courts of appeal are regional. The Ninth Circuit is out west, for instance. The Sixth Circuit is in the Midwest. And so when a district court opinion gets appealed in the federal system and a circuit court of appeals, like the Sixth Circuit, issues a ruling, that ruling will bind all of the courts in that circuit to that ruling. And then if there are differing rulings coming out of different circuits, which happens all the time, someone can then appeal to the U.S. Supreme Court and say, among other things, we need you to settle this issue because we've got different circuits ruling different ways. But some states don't have regional courts of appeal, meaning that in Michigan, they just have a panel of judges who are the Court of Appeals. And when you file an appeal, you're just assigned to a panel of 3 judges who are going to hear your case and render an opinion. But that opinion will then become binding unless it gets overturned by a higher court. Higher court, of course, would be the state Supreme Court, or, of course, if the U.S. Supreme Court would make a ruling that would somehow address that. But in this particular case, the first ruling we got was from a trial court. So when a trial court makes a ruling, it applies to that case and that case only. Only, that's it. So that person who gets a favorable ruling from a trial court goes, hey, I just won. That's cool, I won. But everyone looks to that and goes, but would that be how other courts would rule if faced with the same issue? And you're tempted and you want to believe that other courts would. But I've seen where other courts don't. And I've seen it before, for instance, in Wayne County, where there was an issue that kept popping up over and over again. And you get one judge who'd rule repeatedly a certain way. And I've seen attorneys stand up in another courtroom and say, well, Judge so-and-so down the hall or floor above or whatever ruled thus. And I've seen a judge go, so what? It's not binding on me, is it? And it's not. It's not. To get the binding opinion from this judge to apply to other judges, you need to take it up a step and get the Court of Appeals to say, yes, that ruling was good. But here, the Court on Appeal said the ruling itself, technically speaking, needs to be looked at again. But with respect to the issue of the smell of marijuana, that by itself won't do it. So that was a good ruling for the people who want that ruling. But technically speaking, for the guy here in the case, the judge who now takes the case over could say, well, the smell alone won't do it, but there were other factors involved. And that's the question, were there other factors? So now you might have another hearing. Police might testify again, or they may have to go through the transcripts of what the police said and work off of that. But you run into an issue if the police testify again, because of course their testimony from the last hearing will exist, and it will exist in written form by which they can be cross-examined. And trust me, if you're a defense attorney, that's fun to cross-examine the cops when they are now trying to not change their story, but get a story that kind of helps them now. That's different than the story they had before. And the story they had before was given under oath and is in transcript form that everyone can read and pick apart. So there you go. But the story is out of Pennsylvania from the Court of Appeals. Pot smell alone cannot form the basis for a vehicle search. The Pennsylvania court rules. Questions or comments, put them below. Otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I will choose a path that's clear. I will choose free will.